Hello everyone, and welcome to today's webinar on employment tribunals. This session is the last in the current series of interactive webinars hosted by Fieldfisher's Employment, Pensions, Immigration and Compliance team, also known as EPIC. We began this series in the depths of lockdown as a way of covering significant legal developments in an ever-changing environment, and in particular, reaching out to all our HR and legal contacts working in isolation at home. This session and all our previous webinars have been recorded and are available on our YouTube channel. So if you're holidaying abroad this summer, they are an ideal resource for your 2 weeks of compulsory self-isolation on return to the UK. My name is Richard Kenyon, and I'm a partner in the employment team at Fieldfisher, and I will take the first part of today's session. I began my career as an advocate in what was then the Industrial Tribunal, presenting cases up and down the country, mainly for our big retail clients like British Home Stores, Mothercare and Pizza Hut, and tribunals have remained part of my practice ever since. The other voice you will hear later in this webinar will be the dulcet tones of my colleague and co-presenter Alex Watson. I'll leave Alex to introduce himself to you properly when he takes over as speaker in about 10 minutes. For now, I'll just add that Alex has had conduct of one of the first post-COVID in-person, socially distanced tribunal hearings at the Employment Tribunal in Watford. So that's a hearing with all the parties physically present in one room, not a virtual hearing over Zoom or Skype or Microsoft Teams. And I'm sure Alex will have some interesting insights into how the system is operating and how it will develop in the new normal. Looking at our agenda today, our session is in 3 parts. I'm going to start by covering the period going into lockdown, including delays and how ETs are operating against a likely big spike in claims and possible reforms to the system. Alex will then talk about the practical aspects of dealing with remote hearings, in-person hearings, social distancing and judicial mediation, as we hopefully move to a post-lockdown environment, but obviously still mid-pandemic. And then there'll be some time at the end for questions. If you have any questions, please use the question box in your control panel on the right-hand side of the screen, and we'll aim to get through as many as we possibly can. If we don't have time for all of them, then we'll follow up individually afterwards. So let's get started. Over the years, the employment tribunal system has undergone many changes, often in an attempt by the legislators to make the system more efficient and encourage early settlement. Ironically, almost every one of those changes has had the opposite effect and seems to have resulted in more complexity and longer cases. Tribunals were introduced, let's not forget, originally as an antidote to industrial action. Rather than have mass walkouts in support of a dismissed employee, the system was intended to provide rapid justice, where the primary remedy was reinstatement or re-engagement of an unfairly dismissed employee. Even before COVID-19, tribunals were unfortunately a long, long way from providing that rapid justice. The employment tribunal is not exactly at the priority end of the judicial spectrum. The Nightingale courts, which you may have heard about in the media, are being set up to deal with a backlog of almost 500,000 cases in the criminal justice system, not the employment tribunal's backlog. But the tribunals are not without some resources. Anticipating the likely impact of COVID-19 on employment tribunal cases, the presidents of the employment tribunals issued guidance on the 18th of March 2020, which was about 5 days before the national lockdown was announced by Number 10. That document provided employment tribunals with guidance as to how certain of their powers may be exercised during the pandemic, and provided information to parties about steps the tribunals may take. The guidance reiterates the central importance of the overriding objective to deal with cases fairly and justly, which includes, so far as practicable, 5 separate elements. Ensuring that the parties are on an equal footing, dealing with cases in ways which are proportionate to the complexity and importance of the issues, avoiding unnecessary formality and seeking flexibility in the proceedings, avoiding delays so far as compatible with proper consideration of the issues, and finally, everybody's favourite, saving expense. The tribunal must seek to give effect to the overriding objective in interpreting and exercising its powers, and there's also a role for the parties. The parties and their representatives must assist the tribunal to further the overriding objective, and in particular must cooperate generally with each other and with the tribunal. Now, that's always been the case, but there is a practical point here rather than just an academic point. In the middle of a pandemic, there is arguably more of a role for you as respondents and for us as your solicitors to take active control of case preparation, driving the process with the tribunal and the claimant, and in cutting down and focusing cases in line with the overriding objective. The judicial guidance points out that the tribunal rules already allow for a hearing of any kind to be conducted in whole or in part by use of electronic communication, including telephone, provided that the tribunal considers it just and equitable to do so, and where a hearing is in public, members of the public can hear what the tribunal can hear and see any witness as seen by the tribunal. So the tribunal can make use of remote hearings, but justice must be done and justice must be seen to be done. The 18th of March guidance was followed by further presidential guidance on the 19th and 24th of March. And that provided, as you can see on the screen, that from Monday the 23rd of March, all in-person hearings listed to commence on or before Friday the 26th of June were converted to a case management hearing by telephone or other electronic means to take place on the first day allocated for the hearing. Now, the purpose of the case management hearing was to provide an opportunity to discuss how best to proceed with the case. If the case was listed for more than one day, the remaining days were simply cancelled. In-person hearings listed to commence on or after the 29th of June 2020 were to remain listed and be subject to further direction in due course. And Alex will look at those cases in the second part of this webinar. So as the country went into lockdown, the Employment Tribunal hearings were cancelled and resolution of disputes through full merits hearings ceased. And I want to turn now to some stats from tribunal claims to look and see how that may impact on statistics, looking at some of the historical figures. So on this diagram here, on the y-axis, we have the number of claims, and on the x-axis, we have years. Now, the way that the statistics have been presented over the years has changed slightly, moving from an April to March basis to calendar years, but each bar in my charts represents a 12-month period. Going back in time, Lehman's collapsed on the 15th of September 2008 at the height of the economic crisis. So that's in the middle of the second bar from the left. You will see that the following year, which is 2009-2010, shows the high watermark of claims to the Employment Tribunal when there were 236,100 claims registered by claimants in that period. Now, the number of those claims that related to unfair dismissal, breach of conduct and redundancy, which are claims associated with an economic recession, were 17% higher than the previous year and 62% higher than the year before that. So you can see what happens in a recession. And I'd ask you to just hold that thought. Year on year then, the number of claims began to fall, and you can see a dramatic fall off in 2014 resulting from the introduction of tribunal fees in July 2013. Those fees were finally abolished following a successful challenge from Unison in July 2017. So we can see an increase in cases from 2016 to 17 as the fees were abolished. I've included 2020, but in the words of Jim Bowen from Bullseye, this is what you could have had, because this is an extrapolation of the cases for the first 3 months of the year. So this is in effect the number of cases that we might have had but for COVID-19. Where the 2020 figure will actually end up is anyone's guess. We have a significant case backlog, and we're likely to have a large number of cases resulting from the forthcoming, if we're not in it already, recession. In my final slide, I've set out a few possible developments to watch out for. Lockdown has provided some time for thought, so there may be some tinkering with the tribunal system. Rumours surface from time to time of a reintroduction in some form of the fee system, so that may or may not happen. And also the Law Commission has published a report on employment tribunals in April 2020. The work going into that report would have been done pre-COVID. It makes 23 recommendations, and I've just picked out 3 of them for this slide. Each of the ones I've picked out is likely to lead to an increase in the work of employment tribunals. In turn, they increase the limitation period for bringing claims, so give people more of an opportunity to bring claims. They loosen the rules on blocking claims if they're out of time, and they increase the number of contractual claims that the tribunal could deal with. So that increase is not coming at the best of times, so it may be that those reforms are delayed, but keep an eye out for them. I'll now hand over to Alex to talk about employment tribunals during the pandemic as we hopefully come out of lockdown.
Many thanks, Richard, as I struggle with my mute button just to really live the lockdown dream. And good afternoon, everybody. I am a director in our EPIC team, and just as a very brief background to me and my practice, I've been engaged in contentious employment tribunal matters for the best part of a decade, forming the majority of my work at the moment. So Richard leads us nicely on to the question of what next for 2020. And with a backlog of some 32,000 cases before the lockdown period, and a reported spike in tribunal claims being submitted between March and July, the tribunal service is under pressure to return to some form of normality and clear its backlog as quickly as possible. This pressure is already beginning to tell, as we're beginning to see cases that have been postponed during this period being given new listings as late as spring and summer of 2022 in some regions. Now, during the lockdown, the tribunal has worked quickly with an external provider to support its own cloud video platform, or CVP, which is similar in style and functions to Zoom, Teams, or Skype for Business and similar video platforms. So this adds an additional forum for the tribunal service, alongside its traditional options of in-person hearings and telephone hearings, which have historically usually been reserved for case management or judicial mediation. And in returning to action, the President of the Tribunal Service has identified 3 key phases in 2020 as part of its roadmap to returning to normality, which is split into 2-month windows. We're currently in the middle of the first phase for July and August, which is seeing the Tribunal increase the number of judges available to begin hearing relatively simple unfair dismissal claims, primarily by remote video hearing. The next phase, in September and October, will see greater numbers of more complex claims involving wing members as part of a panel, which will be heard by video as well. So these will begin to address longer and more technical claims, such as discrimination and whistleblowing complaints. November and December have then been earmarked for consolidation, which is likely to mean a further increase in the number of judges being deployed and cases being heard in an attempt to clear the backlog. Since the roadmap's been published, we've been pleasantly surprised to find that the tribunal is already beginning to operate ahead of its scheduled roadmap, with reports that the cloud video platform is operating well. And as Richard touched upon, we've already got some personal experience of complex employment tribunal claims being heard in person at tribunal hearing centres in socially distanced hearings. So no assumption should be made that more cases will be postponed. And with reports that judges, advocates and witnesses all find advantages to remote hearings, we strongly suspect that if the system proves successful as a means of clearing backlog and continues to work practically, that remote hearings are going to become a permanent fixture and are here to stay as part of the tribunal process. So how do remote hearings work? Although based on the same principles and structure as in-person tribunal hearings, there are nuances, and I'm grateful to Employment Judge Warren, who this week provided her guidance and experiences in hosting remote video hearings. But touching firstly on the technology itself. So the courts and the tribunal service have invested in its own video platform, but interestingly and perhaps importantly for people who are engaged in tribunal litigation is that the tribunal does have discretion to use other providers if it considers it appropriate to do so. For example, if a witness could only use an alternative video platform, then it would be open to the tribunal to move away from its own. There is no app or other requirement to download software. It's a streamed platform service, so only a good internet connection, laptop, tablet or smartphone is necessary, albeit that anything with a screen the size of a phone is unlikely to be of much practical use. At the moment, the system is having difficulty with some web browsers, and Internet Explorer is not supported at all, so Google Chrome is recommended. The software is also adversely affected by other video software running in the background, such as Zoom or Skype, so all other similar programs or anything which uses a microphone or video software should be shut down completely to avoid lags in communication or problems with microphones. Unlike hearings in person or telephone hearings where information about attendances or dial-in details, which are usually issued months in advance, the link for video hearings will only be sent several days in advance and will require witnesses and legal representatives to engage in a test connection. So witnesses or anybody else planning on attending should be prepared to be available briefly in the days leading up to a final hearing. In order to replicate in-person attendance at tribunals, the CVP has both a hearing room and a virtual waiting room. When going into a hearing, participants are required to virtually knock before being admitted into the hearing room by either the judge or by the tribunal clerk. Once in the hearing, the platform looks like a standard video conferencing program with all participants shown on video, and it includes chat functions for everyone to use. However, be aware that unlike some other platforms, the chat function will be seen by everybody on the hearing. So some of the whispered comments that I've received about witnesses certainly wouldn't be suitable to be shared with all, so beware chat functions. And finally, on the tech point, the judge and the tribunal clerk will have full hosting powers. So they will admit people into the hearing, but they also have the power to mute and unmute both video and audio for anybody on the call, and they have the power to kick out any unruly attendees into the lobby. So what about the hearing itself? Well, it's broadly going to follow the same pattern that it would at an in-person hearing, and judges are particularly keen to retain the formality and professionalism of an in-person hearing. This is in fact one of the underlying principles behind the video remote hearings. So behaviours should be the same. So that includes staying present during the hearing, not pottering around the room in the background, distracting others, or carrying out any other activities. And unfortunately, it also means that you're limited to having only a glass of water, so no mugs of coffee, glasses of wine, or water bottles. During the hearing, attendees should remain seated, but also be prepared that in some tribunals, we're hearing that judges prefer people who aren't speaking to turn off their videos. And in this respect, the tribunal still expects you to dress for the occasion in smart professional clothing. So both the top half and the bottom half, and sadly, the prospect of cross-examining a witness in pajamas remains a distant dream for advocates. But one of the major challenges for the tribunal is going to be how best to manage witnesses giving their evidence in this virtual environment. In a remote hearing, judges are leaning towards witnesses having to affirm their evidence to be true and correct, rather than relying on giving an oath on a holy book, where the judge and the tribunal can't necessarily ascertain if the witness's holy book is correct or if it's being used correctly. So witnesses shouldn't be surprised or offended if affirmation is suggested by the judge. As with in-person hearings, witnesses are not permitted to be given prompts or to use any prepared notes when giving evidence. Now, in practice, this may prove one of the greatest challenges for tribunals, particularly with instant messaging or email availability for witnesses. We're aware of at least one employment tribunal that's required witnesses to show their camera around their room to prove that no one else has been present whilst on a remote hearing. And whilst it may seem obvious to regular attendees at employment tribunals, we strongly recommend making it clear to witnesses or anybody else who's going to attend that they mustn't contact a witness who is giving evidence or under oath at the same time, for example, by WhatsApp or instant messenger. In preparing for the hearing, the good news is that tribunals are increasingly moving towards the use of electronic trial bundles for the first time, rather than traditional lever arch bundles of papers. Whilst this is good news for the environment in the long run and is often a much smoother process for everyone to see the same documents on a screen, it's sensible for the time being to make sure that all witnesses also have a physical copy of the bundle and witness statements in case there are accessibility problems or formatting issues on different equipment. Otherwise, the judge will lead the hearing in the usual way, and as with hearings in person, advocates can interrupt where appropriate by raising their hand on screen. It's worth noting that more care will be needed to be taken not to interrupt or talk over one another, as I'm sure most people will have experienced at some point on video or conference calls during lockdown. And because of the continued use of screens and the reduced ability to confer with one another during the hearing, judges are also providing shorter but more frequent breaks. Finally, and crucially, as tempting as it may be to record the hearing or to screenshot a judge's terrible wallpaper, this is strictly prohibited and is a contempt of court, so it must be avoided. Finally, there are some top tips for attending remote hearings, most of which are also common to other video conferencing call etiquette. Remember that failing to mute your microphone when not speaking is the video equivalent of reply all, and it has plenty of scope for embarrassing or case-destroying comments. Barks or meows will also inevitably result in grumpy comments from judges. Ideally, attendees should seclude themselves from children and pets in a room with a dark background so that you can be seen clearly in an undisturbed and quiet environment. And people's connections and equipment will vary. So where possible, it's recommended that headsets with microphones are used to ensure that everyone can hear clearly and to avoid feedback or echoes. If possible, we're recommending that everyone taking part in the hearing use 2 screens. This has the advantage of meaning that a witness can view documents on the screen at the same time as the video call, and it avoids flitting between paper documents off screen, which can be distracting or can be stressful for witnesses. If we have any advocates on the webinar today, it's worth noting that some of the barristers we've instructed have reported that having notes for submissions available to them on the second screen also means that having much closer eye contact and rapport can be made with judges has a massive advantage over in-person hearings, so it's strongly recommended. Finally, as with in-person hearings, conferring with legal representatives and witnesses is still going to be key. So whether that's to flag any relevant facts or if a mistake is being made in the way witnesses are being cross-examined, in the absence of being able to whisper to one another or to pass a note, it's advisable to agree a method of communication in advance, which is outside of the scope of the chat in the hearing room. So that might be a WhatsApp group, an email chain, or a separate messaging service. But we just need to be sure that we're careful not to include any witnesses who are giving their evidence at the time that those messages are sent. Finally, even though remote hearings appear to be the future for most of 2020, is that it? Is that what we're left to? Well, in-person hearings are back and they're ready to chair hearings in a tribunal near you soon. I must confess that I was surprised when we were informed by the Employment Tribunal in Watford earlier this month that a 3-day whistleblowing claim would be heard in person and would be attended by a full panel of wing members, particularly as these cases weren't scheduled to be heard even by remote hearing until September or October under the Tribunal's roadmap. So we strongly recommend that no assumptions are made that hearing will be postponed or held remotely during the next 5 months. in particular because tribunals will consider requests from parties for a hearing in person rather than by remote hearing, and will take into account the absence of readily available computer equipment for witnesses or other people who wish to attend. So we are beginning to see in-person hearings occur again. And to accommodate these hearings, the tribunals are taking the responsible social distancing steps, which includes having breakout rooms with notices on the door limiting the number of people in each room. Where there are large parties of people, empty employment tribunal hearing rooms are being used. There are no communal claimant or respondent waiting rooms anymore. Every witness must be provided with their own copy of both a trial bundle and witness statements to avoid contamination. Doors and windows will be kept open wherever possible, and everyone is allocated seating or allocated to a chair, which will be 2 meters apart to sit for the duration of the hearing. Tribunals are also permitting masks to be worn, with a general preference that masks are taken off whilst people are giving evidence, but this may vary from tribunal to tribunal. And oaths are sworn in the same way, but there's no holy book provided, again, to avoid contamination between different people. Unfortunately, despite the measures taken by the employment tribunals to come back up to speed, we suspect that the next set of tribunal statistics, which are due to be released in September, will show a significant increase in both the number of new claims being issued by employees, where redundancies and dismissals are on the increase, and that due to the inability to hear cases between March and June, there will remain a considerable backlog of cases for the next 12 months. Inevitably, that will have an impact on how quickly cases will get to hearing, with late 2021 and spring 2022 currently being identified as the soonest dates for new hearings. But we wanted to touch upon briefly one alternative option for parties, which is to make use of the often overlooked free judicial mediation service offered by the tribunal. This process involves a judge facilitating an off-the-record discussion between the parties with a view to reaching resolution and settlement of claims. There's no obligation on parties to settle a claim through judicial mediation, and either party can walk away at any time. However, this can be an extremely useful tool to focus the minds of both parties, and particularly where a claimant is faced with potentially years before a case can reach hearing, and the benefit of a judge explaining the limitation of any dubious claims. However, one significant advantage is that judicial mediation is frequently conducted by telephone, so can often be arranged within 1 or 2 months of the parties whenever they indicate a willingness to engage in that process. And at a time when significant delays are in the system, judges are keen to encourage parties to consider this approach, and it remains a valuable option. Okay, and we'll check now and see if we have any questions through. Richard, I have one in for you. You have mentioned that respondents and their solicitors are driving case preparation more proactively. Could you give some examples of what you mean?
Yeah, so that very much depends on the nature of the claim, but it might be as simple as a robust challenge to a judge on the number of days that the case is being listed for. It may be that in a complicated claim, certain issues can be taken first and heard at a full merits hearing and certain issues parked. It may be that if a claimant has brought a lot of issues, a lot of examples, for example, that you take their best 10, ask them to identify their best 10 and hear those first. Those sorts of issues. The presidential guidance suggests parties cooperating to produce a statement of agreed facts. Now, all these things were not COVID related. They've been around and possible for a long time. The overriding objective has been part of the tribunal rules for a long time. But I think the effect of COVID is that judges are likely to be much more receptive to parties coming up with ideas to get hearings in place and try and make them more efficient and cost effective and that sort of thing under the tribunal system.
Great, thank you, Richard. I'm mindful of the timing and making sure that we don't run over. So if anybody does have any further questions or wants to get in touch, our contact details are on the screen. Alternatively, as Richard has touched on, all 12 weeks worth of the webinars can be downloaded as one single box set now via our YouTube channel, or otherwise available through our website. So thank you very much indeed to everybody for their time this afternoon, and we hope you found it helpful.